really interesting and important topic. The video that you've just seen has obviously highlighted some of the themes coming out of the recent Supreme Court judgment handed down only a couple of weeks ago. And organisations and individuals are still getting their heads around what it all means for them, for their organisations and for the wider society. But before I start, I thought it was important to say this. This is a very emotive and sensitive topic for a lot of people, particularly those that are either directly or indirectly affected by the judgment. But I only intend to speak about the legal impact of this judgment on sport. So it's not about arguments in the public domain on the meaning of the definition of the word woman, and that's not actually what the judgment was about in any event. And before I start, can I just deal with terminology, because that's also important. The terms that I intend to use throughout this talk are those that are consistent with the judgment. So biological woman, meaning a person who was of the female sex at birth. Biological man being the opposite. A trans woman or transgender woman, a person born of the male sex who has the protected characteristic of gender reassignment, and trans man or transgender man being the opposite. I'm going to then turn to what I intend to talk about in what is really not much time. We could talk about this issue, no doubt, for days on end. I've only got about 25 minutes. So my intention is to firstly deal with the law and the legal position before the Supreme Court judgment, and that will be quite brief. And then turn to the applicability of that to sport previously and cover some of the approaches that sports took when it came to participation before the Supreme Court judgment, and then deal with the ruling itself and what it really was all about. Draw some key themes from the ruling and how they impact on sport. And then finally, I hope to look at what the future of sport might look like and what action, if any, sports governing bodies should be taking in light of the judgment. So I had a slide on the Sex Discrimination Act, but I'm going to move past that. Essentially, the first piece of legislation was the Sex Discrimination Act, but the more relevant, sorry, it's got a mind of its own at the moment. So the more relevant piece of legislation is the Gender Recognition Act of 2004. So many of you will be familiar with that. That act introduced a framework for legally recognising a person's reassigned gender. And there are two important provisions within that act, which is Section 9, and that uses the term Gender Recognition Certificate. And essentially, that is a document which changes a person's gender into their acquired gender. So there's a process that somebody has to go through before that's issued. But what Section 9 says is that that person's gender becomes, for all purposes, their acquired gender. So if the person's acquired gender is the male gender, then the person becomes that of a man, and vice versa. And so the key point there is that the gender recognition certificate legally becomes that person's acquired gender. And the second relevant provision within that act is Section 19. So there's a specific provision dealing with sport, and it introduced the term gender-affected sport. And a gender-affected sport is defined as a sport where the physical strength, stamina, or physique of average persons of one gender would put them at a disadvantage compared to the average persons of another gender in sport. And what the provision says is that a person may be excluded from participating in a gender-affected sport if that exclusion was necessary to secure fair competition or the safety of competitors. So moving then to the next relevant piece of legislation, which is the Equality Act 2010. And that introduced a number of terms which we'll all be familiar with, the 9 protected characteristics, protecting people from unlawful discrimination. And those protected characteristics that are relevant and important here and were relevant in the judgment are gender reassignment, sex, and also pregnancy and maternity, which I'll turn to. What the Act also allowed for was separate spaces for both sexes. Importantly, sex wasn't defined in the Equality Act, where joint services would be less effective. And so you could be allowed to have separate spaces for both sexes in circumstances where that was a proportionate means to a legitimate aim. And in the context of sport, the Equality Act included a provision which dealt with gender-affected activity. And what it said is this, that where there is a gender-affected activity, i.e., as I touched upon, an activity whereby the physical strength, stamina, etc., of one gender puts another at a disadvantage, you can lawfully discriminate on the grounds of sex. Importantly, though, as I said, sex was undefined at the time. But that was all you needed. If you had a gender-affected activity, you could discriminate on the grounds of sex alone. That would justify separate sporting competitions for men and women. The Act also allowed for you to lawfully discriminate and exclude a transgender person from a gender-affected activity, but, and this was the qualification here, only if it was necessary for fairness of competition and or safety reasons. So otherwise, you could not. So you'd have to justify that. And I thought it was important to turn to the science next. So the science tells us that this isn't my personal opinion, this is backed up by research, and this is what was also accepted by the Supreme Court, that the average biological man's physical strength would put them at an advantage as compared to the average biological woman, and that would include stamina and physique as well. Now, of course, there will always be outliers, but the science is based on averages. And so according to Section 195 of the Equality Act, in a sport where this difference would place women at a disadvantage, that would be defined as a gender-affected activity. That would justify the prohibition of a transgender woman from participation in that competition or event, so long as it was on the basis of fairness of competition and safety to competitors. And so in light of that provision, it's consistently been applied to women's competitions and events, because the rationale being that a woman's, and that's a biological woman's, single-sex event, a woman's single-sex event is necessary for fair competition and safety. Otherwise, biological women would be placed at a disadvantage. And so before turning then to the judgment itself, as I said, I think it's quite important here to just deal with some of the different sports' general approach to this issue. Now, when it comes to amateur and elite sports, there's definitely been a difference, a slightly more relaxed approach in the amateur sports space. And some sports permitted transgender women to compete in women's category events, but there was a particular requirement that they needed to satisfy. Ordinarily, that was that they could reduce their testosterone levels, for example, to within the female range, usually over a 12-month period. And the thought process at that point was that that would essentially level the playing field. If a transgender woman reduced her testosterone over 12 months, that would be sufficient in the minds of those sports who had that policy to provide or reduce that competitive advantage. However, the research tells us, and again, not my opinion, this is backed up by the science, that actually that reduction in testosterone of 12 months produces very little reduction in the bone mass and the strength and the body size of a person. And so essentially those biological advantages are largely retained even where that reduction in testosterone takes place. Another factor that some sports took into account was male puberty. And that was considered to be the threshold for deciding whether or not a transgender athlete could compete in their respective sport. So where a person had gone through male puberty, some sports would exclude those athletes on the basis that the physiological advantage that comes with male puberty, i.e. increase in testosterone, etc., would lead to an unfair playing field. Another interesting debate really is about women's puberty, because that hasn't really come into play in the same way as men's puberty. But there is an argument, you might think, that women's puberty, and by that I mean biological women's, places biological women at a disadvantage, because that brings with it wider hips, breasts, menstruation, And therefore, even where a person has not entered male puberty, there may still be thought to be an advantage over the biological female in any event. Just an interesting thought there. Turning to how different sports had previously approached the issue of participation. So boxing, as you'll see there, took quite a hardline approach. And the IBA rules on gender state that boxers will compete against boxers of the same gender, meaning women versus women and men versus men, and they properly set out what that meant within their transgender policy and said that a woman means an individual with 2 X chromosomes, i.e. a biological female, and a man means an individual with an X and Y. Arguably, boxing is one of those sports where you really can justify that separate competition for biological women, as the sport really is primarily based on physicality, strength, and stamina in the way that some other sports might not be able to justify. Turning then to rugby, contact rugby, not touch rugby, they held a previous policy which was based on the testosterone levels that I touched upon earlier. And the premise was that lowering the testosterone would be sufficient to ensure fair and safe competition in the women's sport. However, the research that I spoke about was taken into account by those that govern the sport, and actually they changed their policy and introduced a prohibition on transgender women from elite rugby. And they cited significant safety concerns, and you'll see there, they said that the safety and fairness of the competition cannot presently be assured for women competing against trans women in contact rugby. Now, some sports that have imposed prohibitions on transgender women participating in women's competitions and events have introduced what's called an open category to allow for transgender participation. So an open category is a category that allows participations from athletes regardless of their gender identity or their assigned sex at birth. So it means, and it aims to be a more inclusive category, providing an alternative to the separate and male-female categories. British cycling, for example, replaced their entire men's category with an open category. So essentially, within that open category, you were allowed to be a transgender man, a transgender woman, identify as non-binary, as well as be a biological female. So they retained their biological female-only category. Now, this is probably the right time to come to what the ruling was all about. Now, despite what's been said in the press, as I said right at the outset, this wasn't about defining the word woman. The question for the court was a matter of statutory interpretation, as I'm sure most of you in this room will know. And the 2 protected characteristics that were relevant or at the heart of the case were sex and gender reassignment. And the central issue was whether the references in the Equality Act, as I said earlier, to sex, woman and female, were to be interpreted in line with the Gender Recognition Act. And you'll remember I touched upon that right at the outset. This was about the Gender Recognition Certificate. So Section 9, just to bring it back into play, is where a person is issued with a Gender Recognition Certificate, their gender becomes for all purposes their acquired gender. So the question was essentially, when one has a Gender Recognition Certificate and they have acquired a new gender, are they to be considered to be a woman? Are they considered to be female? And is their sex that of their acquired gender for the purposes of the Equality Act? And that's the crucial point there, for the purposes of the Equality Act. So that was the issue the court had to grapple with. Now, what the court determined, and it's an 88-page judgment, so I obviously can't go into all of the detail, but the high points are that to consider those with a full gender recognition certificate as equating to biological sex would be, in their view, an interpretation that produces unworkable, impractical, or illogical results, and was therefore unlikely to have been what was intended by the legislator, bearing in mind, of course, that they were interpreting the statute. And they gave the example of pregnancy and maternity. And the court stated that this, for example, was a unique experience that was restricted to biological females. And so the protection afforded in the Equality Act under the term pregnancy and maternity was predicated on the basis that a person had given birth and taken a leave of absence in consequence. And so their view was that as a matter of biology, that must necessarily be restricted to biological women, and it could not have included, importantly, those with a gender recognition certificate. And in relation to sport, the court expressly said that it was plainly predicated, i.e. the Section 195 of the Equality Act, which deals with gender-affected activity. They say that was plainly predicated on biological sex, so that's completely unambiguous. They're quite clear about that. And may be unworkable, they said, if it was to include those with a gender recognition certificate. So that's the key point there. And they used gender-affected activity to demonstrate their example of why they thought this would be unworkable. And what they said is when you talk about averages between the two sexes, that if the average biological woman compared with the average, if the average woman compared with the average man were to include those with gender recognition certificates, as was argued on the other side, then those differences that we identify in strengths, in stamina and physique between the two groups may begin to fade, because within the group of women would be those who had a gender recognition certificate and were therefore biologically male. And they said that could not have been the intention of Parliament, because it would mean the provision would become illogical and unworkable. And so persons with or without a gender recognition certificate are not to be treated as anything other than the sex they were at birth. That was what the Supreme Court stated. And so when you go back to Section 195 of the Equality Act, which says that it's permissible to discriminate where you have a gender-affected activity solely on the grounds of sex, there lies the answer for some sports. And so the Supreme Court said that the meaning of the term sex, man and woman in the Equality Act is biological. It's not certificated sex, and that any other interpretation would render the Equality Act incoherent, impractical, and would not operate properly. And what they said for anyone that was concerned about transgender people being discriminated against or not having proper protection, the Supreme Court said that the Act does provide sufficient protection for those that are from the transgender community under the protected characteristic of gender reassignment. And biological women are protected under the protected characteristics of sex and also pregnancy and maternity. So the court were clear about that. Turning then to some of the considerations for sports to consider in light of that decision, I thought that two to draw out would be female-only categories and how sports will treat those in the future, and single-sex spaces, which was also provided for in the Equality Act. And so turning first to single-sex spaces, what the ruling says now and says is that the provision of separate services for persons of each sex, i.e. biological sex, will not constitute unlawful discrimination, where joint services, so unisex services, for both sexes would be less effective. And so provided that having separate sexes, private spaces, was proportionate means to achieving a legitimate aim, there's essentially no discrimination there. So what that essentially means is that where you have a woman-only space, then a biological man who identifies as a woman, i.e. a transgender woman, cannot use it. So that would include things like changing rooms, toilets, and anywhere designated as for one sex only. And this is a really interesting point, I think, for sport. I'm going to use an example that's unrelated to sport, which is the British Transport Police. They are one of the organisations who have changed their policy following the judgment. And in relation to searches and strip searches, they now say that transgender women will be searched by biological males. They'll be treated, transgender women, as biological males when it comes to searching and strip searching. And so what does that mean for sport when we look at things like anti-doping and we look at urine samples being taken by transgender women? There's an issue to grapple with there, not necessarily from a legal perspective, but from an inclusivity perspective, at least. And what the ruling states is that separate spaces should exist, unless you can demonstrate otherwise. And it's likely to be easily justified, in my view, on the basis of privacy and dignity. So you can have a unisex space, but you need to also have single-sex spaces, unless you can justify that. The female-only category in sport is another area which I think is obviously going to be of concern to sports moving forward. And what I've said here is that there really is more clarity than ever before. If there was a grey area before, then it's no longer there. Sports can create or retain separate women's categories for biological women only, provided, of course, that they are gender-affected activities. So they still need to be able to justify that the sport is one where strength, stamina, and physique will be a relevant factor. So while the ruling means that organisations can exclude trans women from these spaces, they're not obliged to do so. They just need to be able to legally defend that position. But any sport that continues to allow transgender women to compete in women's sport are, in my view, likely to face legal challenge on the basis that amounts to indirect discrimination to biological women. And we're actually seeing more and more sports changing their position following the ruling. No doubt you'll be aware of these. I, in my slide, had touched upon eight-ball pool, but you'll know, some of you that have been on your phones over the break, that there's been a number of other sports that have followed suit relatively recently. So I'll start with eight-ball pool, because that's on my slide. So they came out last week and said that transgender women would no longer be permitted to compete within the female pool category. They've revised their policies following the ruling, and the sports governing body for pool considers pool, although this might be a surprise to some people, but it's a gender-affected sport. And so what they say is in Q sports, female players have unique disadvantages compared to male players, and that transgender women retain the male advantages. So they are, or were, the first sport to make and take a hard line on this. I then had Scottish FA in my slide, and they have announced that they intend to also change their transgender policy and impose a prohibition on players who are not biologically female in women's competitions. And what I was going to say was it would be interesting to see what the English FA do, but for those of you, as I say, that have been on your phones over the break, you'll know that the English FA today announced that they also have introduced a prohibition on transgender women in women's football in England. And that's an interesting development, because some of you might know that the FA had introduced a transgender policy only a couple of weeks before the Supreme Court judgment. And they, in that policy, had said that provided that testosterone levels were reduced, bearing in mind that was the position before the research came out, that transgender women could play in that sport. They've changed their position. I'm told as well, just as I was about to come on, that netball have also announced today that there will be 3 separate categories: a biological women's category, a biological men's category, and a mixed category. And so, looking ahead then, the ruling really does provide legal clarity to organisations who had previously struggled to navigate this space, with sporting considerations having been taken into account, but also political. And as I've said, a number of sports have shifted their position since the ruling, and I was going to say that I think many more sports will do this, but I've already made that point. The ECHR have said that they are going to issue some guidance about this, because people are still trying to work it all out, and that guidance is expected to address inconsistencies in policies across sectors, including sport. One interesting thing to think about looking ahead is the International Olympic Committee, for example. Their transgender policy allows international federations to set their own eligibility criteria. And so we're looking forward to Los Angeles 2028, where we may no doubt see different and conflicting policies between athletes playing out from different nations. President Trump, somebody that I never thought I'd mention in a legal talk, has taken, obviously, as you know, quite a strong stance on the prohibition of transgender women in sport. So it'll be interesting looking forward to see how that develops. I have then included some practical considerations for sports, but I'll whiz through those because I think I might be out of time. What I've set out there is just, firstly, that governing bodies are not mandated to amend or reconsider their rules immediately. There's nothing to say that they should do that, but obviously we can see that that is what's happening. Sports are interpreting this judgment in the way that it probably should be interpreted if they want to err on the side of caution, avoid litigation. So recognising, firstly, that policies which are not based on biological sex might result in unlawful conduct. So policies need to be clear and simple. Sex means biological sex for the purposes of the Equality Act. Having the protected characteristic of gender reassignment or having a gender recognition certificate does not change a person's biological sex for the purposes of the Equality Act. Another consideration is just ensuring that biological sex-based rules are clear and justified. So if you are going to treat people differently because of their protected characteristic, then identify the reason why and the lawful exception. The judgment has put it beyond doubt that the Equality Act requires single-sex services. And if you provide a single-sex space or you intend to have a single-sex sports competition, then you need to make that clear that it's for people of that biological sex only. But that doesn't... To remove single-sex spaces altogether and make them gender-neutral is unlikely to be justified and could amount to discrimination. But if one was to decide to provide joint spaces, then that would need to be legally defensible. And as I've said for the reasons earlier, I think it's unlikely that will be. Unisex spaces are right and proper, and the transgender community should have somewhere to go to. But what the ruling is saying is that biological sex spaces are also necessary. If you are to include transgender athletes in your women's sporting competition, you must think very carefully about whether that is legally defensible. And as I said, you may still be at risk of indirect discrimination against biological women. Finally, the conclusion. The ruling provides a sound legal basis now for classifying and prioritising biological sex when defining female categories. There's no room for ambiguity. If there was before, there certainly isn't now. Sporting bodies will therefore need to review and clarify their policies, which they're clearly doing. I've said in the near future, but this is happening as we speak. And that goes for not only the elite level, but also grassroots sports. They need to ensure they're acting lawfully. But it's also important that sports governing bodies continue to strive to preserve sporting integrity, fair competition, whilst also balancing the importance of inclusion. So whilst this is certainly firmer ground for sporting bodies, there will no doubt be pressure to ensure that sport remains inclusive, whether that's through open categories or additional facilities for transgender athletes. So that remains to be seen. And that's the end of my talk. Thank you for listening.